Hey everybody, this one is Do-It-Yourself Kangaroo Courts number 5, Testifying by the Liars. And actually that should say lawyers. No, actually it should say liars. Kangaroo courts are everywhere. Kangaroo court is a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded and in which the result is a foregone conclusion because of the bias of the court or other tribunal. Part 1. We talked about all courts, two general kinds, 3 general types of jurisdiction, what a kangaroo court is, why they're holding a kangaroo court, why they want you to have a liar, and how to tell it's a kangaroo court, and what they do in a kangaroo court, and how they're Satanists. Part 2 was how to tell it's a kangaroo court, and what they do in a kangaroo court, and what's been done by others to defeat their kangaroo court without going in. Some things to do if they drag you in there. Part 3 is if they want you to plea bargain. What happens if you do enter into a plea bargain? Part 4 is it is Roman cult commercial warfare. It's a contract. It is a contract. Where's the contract? Where's the benefit I'm supposed to have taken advantage of that subjects me to this? Admit nothing, make them prove everything, object to everything, reject their contract at allocution. And now this one's part 5, object to testifying by the liars. It's an admiralty proceeding, and the so-called judge is a clerk masquerading as a judge. The clerk is sitting there playing stupid, and if you do not object, then the bail priest will accept it as true. An attorney for the plaintiff cannot admit evidence into the court. He's either an attorney or a witness. Okay, and that's exactly what these liars do, okay, is they sit there and they'll make a bunch of statements, and if you don't recognize that they're testifying, then and object, then the clerk masquerading as a judge will accept it as true. Manifestly, such statements cannot be properly considered by us in the disposition of a case, and that's U.S. Supreme Court. Gonzalez versus Bust, U.S. Supreme Court, again, on a no possible view, however, of the findings we are considering, can they be held to constitute a compliance with the statute, since they merely embody conflicting statements of counsel concerning the facts as they suppose them to be, and their appreciation of the law which they deem applicable. There being, therefore, no attempt whatever to state the ultimate facts by a consideration of which we would be able to conclude whether or not the judgment was warranted. And so that's exactly what these liars do, is they get in there and testify. No instruction was asked, but as we have said, the judge told the jury that they were to regard only the evidence admitted by him, not statements of counsel. And so, and many juries are as brain dead idiots about it too. Anyways, watch my jury nullification video. The prosecutor is not a witness, and he should not be permitted to add to the record either by subtle or gross improprieties. Those who have experienced the full thrust of the power of government when leveled against them know that the only protection the citizen has is in the requirement for a fair trial. And again, that's U.S. Supreme Court. Statements of counsel in brief or an argument are not sufficient for a motion to dismiss or for summary judgment. Statements of counsel in brief or an argument are not facts before the court and are therefore insufficient for a motion to dismiss or for summary judgment. And now a little advertisement. Don't forget to subscribe to this channel. Don't forget to click the bell next to the subscribe button so when you're notified that you are notified when there's a new upload. And this is the front page of the channel, and you notice the arrow is pointing to the little bell. You got to click on that, and that way you'll be notified when there's a new upload. Now back to the topic at hand. There's no common law crimes in the United States. There are no common law offenses against the United States. Only those acts which Congress has forbidden with penalties for disobedience of its command are crimes. And so that's a symptom that you're under martial law. That's exactly what it is. Under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense and in the same enactment provide exceptions to its application. And so again, that's a symptom or a sign that you're under martial law. Everything's in admiralty. A writ of error doth not lie upon a sentence in the admiralty, but an appeal. Well, anytime you appeal anything, it's to a court of appeal. So they're all admiralty. Appeals are in admiralty. This is citing Tomlin's Law Dictionary 1835 edition, but they're citing Book 4, Coke on his Institutes and the Laws of England, and which is in the 1500s. And so it's called a Court of Appeals. It's the same thing that precipitated the War of Independence. Everything's in Admiralty. This is the causes and necessities for taking up arms, 1775. Statutes have been passed extending the courts of Admiralty and Vice Admiralty far beyond their ancient limits, for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish an order and use the exercise of law martial, and for altering fundamentally the form of government established by charter. And that's what these Satanists do. Declaration of Independence, it's basically a list of grievances for abolishing a free system of English laws on a neighboring province, establishing therein an arbitrary government. Gee, that sounds like a military dictatorship. And enlarging its boundaries so as to render it as once an example and fit instrument for introducing the same absolute rule into these colonies. Military dictatorship. He's abdicated government here by declaring us out of his protection and waging war on us. Military dictatorship. For protecting them by a mock trial. And this is non-ratification of the 14th Amendment by Judge A.H. Ellett of the Utah Supreme Court, and it's associated with a case called D.I.Y versus Turner. Congress, claiming its martial law power to declare war, suppress insurrection, and repel invasions, imposed martial law on the United States and never discontinued it. The result was an extension of the military and municipal jurisdiction of Congress. But where's the evidence of this? Look at the 13th Amendment, the Civil Rights Act, the legal tender laws, the 14th Amendment, etc., etc., etc. The 14th Amendment is an extension of the national military powers presently used in a municipal character and enforced by municipal laws stretched far beyond the original limitation and enforced by Article 1 tribunals. And that's again Judge A.H. Ellett and his non-ratification of the 14th Amendment associated with D.I.Y versus Turner. No common law means martial law. And announcing another subscription-based YouTube channel called Sovereignty International. The recommended cost of the subscription is currently $1.99 because it avoids the advertising only. I was originally going to have some exclusive material on that channel, but I, after giving it some thought, the only power that these New World Order Satanists have over us is through fraud and deception. And my agenda is to expose it all for our benefit. And so therefore, I can't think of anything that I want to have on there exclusively. I may put something on there exclusively, but so your really only advantage is that it'll avoid the advertising. But it's a good way to make a donation too. So I would encourage you to subscribe. But there will be very little exclusive material. I'm currently publishing 6 videos a week, and some people have said they had trouble finding it, and so I put a link at the very bottom there of how to find the channel. Now, this is actually the channel, and some people have sent me donations, and you have to understand that that you can send me a donation, but I cannot sign anybody up to this channel. You have to do it yourself through YouTube. And that's why you got to start the free trial and set up some sort of, I'm not even sure how YouTube handles it, but I know that they'll probably take a cut, and then I'll get what's left. But the bottom line is that I cannot, if you send me a donation of $1.99, I can't sign you up to the channel. Sorry. So you got to do it this way. It's just physically, I mean, what I have as far as all my settings and stuff like that, I don't have that option. Anyways, a penal action is an action on a penal statute, an action for recovery of penalty given by statute. So you have to understand that all statutes are contracts, and it goes directly to the Roman cult. Where an action is founded entirely on a statute, if the only object of it is to recover a penalty for forfeiture, such action is a penal action, okay? And, let's see, oh no, yeah, okay, I must have bumped it. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture or to be forfeited for non-compliance with an agreement. Okay, they assault you with one of their Roman cult contracts. The words forfeit and penalty are substantially synonymous. A penal action is one founded entirely on statute brought within the sole object of recovering a penalty or forfeiture imposed as punishment for the specific offense, while a remedial action is one brought to obtain compensation or indemnity. And so a penal action is one founded entirely on statute. The only object is to recover a penalty or forfeiture imposed as a punishment for a certain specific offense, while a remedial action is one brought to obtain compensation or indemnity. Okay, so this last two, let me go back. It looks like those are very similar, although they're definitely different. One's Oklahoma and Cummings versus Board of Education, and the other one's Smith Engineering Works versus Custer. Anyways, a penal action is a civil suit brought for recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions, on the one hand closely related to criminal prosecutions, and on the other actions for private injuries in which the party aggrieved may by statute recover punitive damages. And so again, there are no criminal actions. And that's why when you go into these so-called courts and you ask the judge, well, what's the nature of this accusation that you've got here? And they'll say, it's quasi-criminal. Well, it's civil, okay? And it's a civil suit, and they're assaulting you with one of their so-called contracts. Allegations of legal conclusions providing only the notice of the nature of the offense defined by statute upon appearance ticket or citation cannot be permitted to supply essential allegations of fact. A mere conclusion of a pleader, which is, and stuff in square brackets isn't there, it's just kind of elaborating on it, so I'll read the stuff outside the square brackets. A mere conclusion of the pleader cannot be availed of to initiate and invite an issue of fact. Allegation of conclusion of law tenders no issue. Okay, so that's what these Satanist pigs like to do, is they just automatically assume you're one of the slaves, and if you don't dispute it and do it in the right way, then you get assaulted, and they get away with it. They collect a royalty, these Satanists. Where there are no depositions, admissions, or affidavits, the court has no facts to rely on for a summary determination. If the record does not show upon its face the facts necessary to give jurisdiction, they will be presumed not to have existed. A pleading cannot be aided by reason of facts not averred. Facts necessary to a cause of action but not alleged must be taken as having no existence. And so, and this is a government of Virgin Islands versus Giroux cannot assume facts not in evidence, even if the judge believes the facts to be accurate. And so again, unless you start pointing this stuff out, the bail priest is sitting there playing stupid, and he'll just go ahead and railroad your butt. And a clerk masquerading, and that's what I'm saying. The clerk masquerading as a judge is sitting there playing stupid. This is Williams versus United States, U.S. Supreme Court. This is about legislative courts, and they only issue advisory rulings. Well, all of these courts are legislative courts. There are no Article 3 courts. These judges are not Article 3 judges. I just went to the Supreme Court, and when I went and one of the questions, it was certiorari, and I used this case to bring up the issue that a court of appeals is not an Article 3 court. They don't have the right to convene a common law jury, and so then they're not an Article 3 court. So let's read this case anyways, because this is the case that I used. And so it is noted as significant that the act constituting the court dispenses with trial by jury, a provision which is distinctly upheld in spite of the Seventh Amendment in McElrath versus United States. With respect to the status of the court, the opinion concludes, while what has been said of the creation and special function of the court definitely reflects its status as a legislative court. And if you go on from the outset, Congress has required it to give merely advisory decisions. Under the Act creating it, all of the decisions were to be of that nature. This is true at the present time, a duty to give decisions which are advisory only, and so without force, as judicial judgments may be laid on a legislative court, but not on a constitutional court established under Article 3. And so it's amazing how after I filed my petition for certiorari, now you go to the U.S. Court of Appeals for the Fifth Circuit, and they don't say anything about having Article 3 judges there. It's amazing how that works. And so now I'm going to do it with the bail priest in the Ninth Circuit. And that's Williams versus United States, 289 U.S. 553. So the judge works for the state, the prosecutor works for the state, the police or witness works for the state. You see, they all have their bail priest uniforms on, okay, except for the pig. He's got his Roman cult uniform. They're all Roman cult uniforms, but the bail priest and the prosecutor both have their black robe military uniforms on. They're all military uniforms. The vast majority of the disputes that the police initiate on behalf of their employer are also adjudicated by their employer, where the plaintiff, the judge, the antagonist, the police, and the only witness, also the police, all represent the same party. And since no corpus delicti, mens rea, or acts reus can be produced, doesn't technically qualify to be heard according to its own laws. The state, therefore, is indistinguishable from a criminal cartel. They're a bunch of thieves. That's exactly what they are. It's a kangaroo court. So the bail priest asks, are you the name? Okay. And they're not telling you that it's the name of a Satanic Trust is what it is. And so then the answer is if I give you my name, is that a contract? Well, they don't want to answer that one. And so they may answer it, they may not. And then what you say is, I neither admit nor deny anything. The burden is on the prosecutor to prove his case. And they'll probably throw you out of there, but then they'll send you some letters from what I'm hearing from people trying to get you back in the contract. And so, you have to understand what's going on. You reject their offer of contract. That's all for Satanic Trust for their U.S. citizen slaves. And this is Henry Boland's. Every taxpayer is a Satanic Trust having sufficient interest in the preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. And this is a citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary, the public charitable trust, the constructive Satanic Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the U.S. and USA and U.S. Inc. And that is a summary. I get people contacting me all the time about this because they're saying, I went and looked through there and I can't find this site anywhere in there. Well, think about it, okay? It's 15,641 to 15,646. There's no way that if anybody's looked at the congressional record, it's extremely fine print. It's 3 columns. It's not gonna be cited. It's a summary of what those pages say. Hello, the lights are on. Is anybody home? This is Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. I'm glad you're checking though, because you should be checking. But that's a summary. Yet still it was found difficult to set bounds to ecclesiastical ingenuity, okay? So we're talking the Roman cult here, okay? The Satanic Trust comes from the Roman cult. For when they were driven out of all their former holds, they devised a new method of conveyance by which the lands were granted, not to themselves directly, but to nominal fiefs to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy. The Roman cult, still under the direction of the Roman cult, to be bound in conscience to account to his Satanic Trust for the rents and emoluments of the estate. Well, that's taxes, people. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. Well, if it was the foundation of modern conveyancing in 1835, it's still the foundation of modern conveyancing today. On another advertisement, other videos. Check out my other videos, Bankster Thieves 1, 2, and 3, Churchianity Series, Bankrupt Corporate So-Called Governments, Bar Members 1, 2, and 3, Do-It-Yourself How Not to Volunteer for the Selective Service, Martial Laws Here, Do-It-Yourself No Income Tax, Do-It-Yourself No Sales Tax, Do-It-Yourself Traffic Stop 1 and 2, Do-It-Yourself Free Mail, Do-It-Yourself Kangaroo Courts 1, 2, 3, and 4, and now this one is 5. And so, alternatives. What you have to do is make it so they do not want to talk to you. See my Do-It-Yourself Estoppel Certificates video. You put them into estoppel. You can also file a notice of void judgment into the case. And you can also demand a trial by jury. I try not to go in there. Sometimes they just drag you in there, and so then you have to deal with it. But quite frankly, I don't go in there. I file a lawsuit if I have to, and that operates as a counterclaim. But you have to understand that these people are cowards, okay? These pigs and their bosses are operating a criminal street gang. They're engaged in fraud to get you into one of their so-called contracts. And why do they lie? Think about it. Why do they lie? It's because they're cowards. All liars are cowards. They're afraid to tell you the truth. They want to get you into one of their so-called contracts. They're afraid to tell you that they're perjuring their oath and assaulting you with their so-called contracts. All liars are cowards, if you think about it. Why would they lie? It's because they're a coward. These people are all cowards. That Baal priest is a coward. He's sitting there playing stupid, and they're railroading you. They're nothing but a bunch of criminals is what they are. And they you know, in the Bible it says that people that sell other people into slavery should be put to death. And quite frankly, I think it's going to come to that. Anyways, the Dalai Lama, when asked what surprised him most about humanity, answered man, because he sacrifices his health in order to make money, then he sacrifices money to recuperate his health, then he's so anxious about the future that he does not enjoy the present, the result being that he does not live in the present or the future. He lives as if he's never going to die, and then dies having never really lived. Well said, Dalai Lama. If ye love wealth better than liberty, the tranquility of servitude better than the animating contest of freedom, go home from us in peace. We ask not your counsel or arms. Crouch down and lick the hands which feed you. May your chains set lightly upon you, and may our posterity forget that you were ever our countrymen. And nobody could say it like Samuel Adams. When shall it be said in any country, the world, my poor, are happy, neither ignorance or distress is to be found among them. My jails are empty of prisoners, my streets of beggars. The aged are not in want, the tax is not oppressive. The rational world is my friend, because I am friend of its happiness. When these things can be said, then may that country boast of its constitution and government. Well, we have nothing to boast about here. We had, past tense, a bunch of criminals running the government. We still have a lot of criminals in the government. I think this new administration hopefully is going to make a difference, but that's yet to be seen. We'll see. So far, he's off and running big time, though, I got to tell you that. And that's what I'm talking about, Trump. But the streets are full of beggars. The jails are full of prisoners. They're busting at the seams. And the taxes are oppressive. And so we have nothing to be proud about here. But if the watchmen see the sword come and blow not the trumpet, and the people be not warned of the sword come, and take any person from among them, he's taken in his iniquity, but his blood will I require at the watchman's hands. This is my effort to make sure that I'm blameless on Judgment Day. Either you're part of the problem or you're part of the solution. You're now a watchman. Circulate this video far and wide. Copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. I have YouTube videos that are videos of private information shares. They show these and other court citations that are available for other donation. And this last paragraph is for all the Satanist order followers operating under the Federal Tax Lien Act of 1966. The revenue officers in their private capacity, because I prefer gold or silver coin. They can put their privileges and benefits up their rectal orifice. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept their IOUs, Federal Reserve notes, PayPal, guest checks, money orders, etc. Send me an email for particulars. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email is engineerwin@yahoo. My YouTube profile is Sovereign Living and Sovereignty International. And my Facebook community page, I deleted it due to censorship. My private group is being deleted. It takes a while to ban 17,000 people off a group. My Yahoo private group is called Administrating Your Public Servants, and my Google private group is called Administrating Your Public Servants. I appreciate you taking the time to watch the video. I hope you get something out of it, and at least you're a little bit more knowledgeable about what goes on in these kangaroo courts nowadays. Have a great day.